seem to follow the rules.
She kept chasing me. That's it. And then she went to talking about calling the police and all that. She control thing she's trying to do. That's it.
I don't care what it is. You have got all of these charges.
I understand.
You just need to just stop blaming them.
Buckle up, because today's courtroom drama is heating up. Judge Simpson is taking no nonsense as he faces off with a defendant who just can't seem to follow the rules. This guy is back in court after tampering with his tether device. Again. And to make matters worse, he went right back to seeing the very woman involved in his previous domestic violence case. Judge Simpson isn't here for excuses, and he wastes no time delivering a blunt reality check. Messing with your tether. That's a fast track to a jail cell. Violating court orders? Even worse. But does the defendant own up to his mistakes? Not exactly. He's got plenty of excuses. This one's intense, so stick around and drop your thoughts in the comments. Let's watch as Judge Simpson lays down the law.
Warning. I believe
On the one case, I have a new case, however.
I was unaware there were new charges, Judge. But I don't know if this court's prepared to arraign my client.
I am.
Okay.
And I don't know. You're going to stand in for the purposes of the arraignment.
I'll be filing an appearance, Your Honor. I was unaware, but the charge, I would have filed one already.
It's a charge of interfering with electronic communication device, the 2-year felony, and then also domestic violence, second offense, the 1-year misdemeanor.
Yes, Your Honor. As it relates to both those charges, waive any further reading of the warrant. Stand mute to both those charges.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. I'll set a probable cause conference in that case for, I need a DV bond form, please. For November 14th, 2024 at 9 a.m. or as your invite indicates. As to bond in that case, you want to say?
Yes, Your Honor. Obviously, Mr. Carter's here on his own voluntarily this morning and this afternoon. And obviously the court knows his history of appearance in front of this court. And Your Honor, he just got a new job. He was, unfortunately, he lost his other job due to this incident, but he just got a new job that he'll probably lose if he's in custody. Judge, it does appear that the complaining witness in both these cases is the same person who has actually reached out to me before, Your Honor's indicated her, I believe, unlikeliness of appearance in the case. I don't think she wants to proceed with the case, but that's my understanding anyway. People might have a different position, Judge, but she's reached out to me independently and indicated that she does not want to proceed with those charges. But be that as may, Your Honor, I don't believe my client's a flight risk, and he's still on what's that? He's still on a tether, Your Honor. He did post a significant bond in the last case. I understand these are new serious charges, Judge, but I'm asking the court to consider.
Look, I get that the lawyer is doing his best, but let's be honest. This guy completely set himself up for failure. He didn't just ignore the judge's warning. He walked out of court, stared the law straight in the face, and said, "Rules? What rules?" Instead of keeping his head down, he went right back to breaking the exact conditions Judge Simpson laid out, like being told not to touch the stove and immediately slamming your hand on it. What did he think was going to happen? And now he's standing there, acting surprised, as if this wasn't the most predictable outcome ever. But trust me, the real wake-up call is coming. Judge Simpson isn't about to let this slide, and when the hammer drops, it's not going to be gentle. If this guy thought he could just talk his way out of it, he's in for a rough reality check. Because one thing's for sure, judges never forget. He might want to get comfortable because chances are, he's not walking out of that courtroom a free man.
I have some advantage because I do have the police report for the newest case. Mr. Burgess does not, but I will indicate to the court a few things. First of all, this court arraigned defendant on not his newest felony that he was just arraigned on, but the one that's set for preliminary examination tomorrow on October 7th. At that time, the defendant was ordered not to have contact with the victim, Jennifer Matlock. The new date of offense for the newest case that we're here for today that the defendant is alleged to have committed is October the 20th. So weeks later, and I will tell the court after review of the police report, the person representing themselves to be the defendant, they have contact with the police officer and admitted to having contact with the victim. Denied the assaultive behavior, but did admit to having contact with her. Now, because the defendant, because the police officer was speaking with the defendant face to face, I cannot say with absolute certainty that it was the defendant. However, the police officer did a very good job in their report of detailing how he came into contact with that person, that this person kept called him back or presented themselves to be the defendant, and said that he would turn himself in for the bond violation. I don't have a record that actually happened. So Your Honor, in any case, this is somebody that was on the score for probation, on bond for a felony, and now has picked up another new felony. So I am asking the court to follow probation's recommendation about the probation and sentence the defendant to serve balance at this time. And in bond in this case, we're assessing for $100,000 for the new felony.
Court will order as a condition of the bond that there's to be no possession of any alcohol, illegal drugs, or any recreational marijuana. I'm not entirely sure what is going on with you in that regard. I ordered you on the 7th not to have contact with this person. And then, lo and behold, we end up with this case occurring less than 2 weeks later. And tried to give you every benefit, and I understand there are only allegations, but try to give you the darn benefit of the doubt regarding everything because of at least the way that you conducted yourself in regards, particularly regarding being a flight risk. But you just can't seem to follow the rules.
Your Honor, I'm sorry. I don't mean to interrupt.
Go ahead.
I'm sorry, Judge. Judge, the incident on the 20th, based on conversations I've had with my client as well as the complainant in this case, the complainant approached my client, asked for a phone back he had purchased, but it was in her name, which he returned to her. That was the basis of the contact. That's our understanding of it, Judge. So I wouldn't. But
Right. But the thing is,
I know.
he needs to be turning around and running in another direction. He shouldn't even be having a conversation, shouldn't be doing anything
I agree.
whatsoever. I don't think it's at all unclear as to anything that this court has said to you regarding what you need to do. And you need to just follow the rules. I gave you a break the last time that you came in. Even after that, let you...
Oh, this is about to be gold. Let's break this down real quick. This guy has a restraining order. The court spelled it out in big, bold letters. Stay away. No calls, no texts, no accidental run-ins, just don't. And yet, here we are. He got caught meeting up with her again. And the best part, he actually thinks he can talk his way out of it. I already know whatever excuse he's about to drop is going to be next-level ridiculous. There is no possible way he can spin this to make himself look innocent. But I cannot wait to hear him try. Honestly, at this point, his best bet is to claim he was kidnapped and dragged there against his will, because that's about the only excuse that even sounds remotely believable. And you know Judge Simpson is about to torch him for this one.
Playing my game, and she came in the room. And
Then you get up and leave.
tried to leave. She kept chasing me. That's it. And then she wanted to talk about calling the police and all that. She's chasing me. She's chasing me. She's chasing me. I hopped in my car, and that's when I pulled off.
Well, maybe that's all going to come out, Mr.
I understand.
Carter. Maybe that's all going to come out. I let you out the last time. Should have, of all rights, locked you up on that date. Didn't do it. Gave you the benefit of the doubt because of the time that you came back after you were inadvertently released by the jail. And then what happens? You get that other case set for exam. Then what ends up happening? I get here and you've got another case.
It's a control thing she's trying to do. That's it.
I don't care what it is. You have got all of these charges.
I understand. I
And you're the one under the jurisdiction of the court. So however you got to figure it out, you need to figure it out.
Yes, sir. Yes, sir.
Defendant's bond on that case would be set in the amount of $100,000 cash surety. On his other matter, anything you want to say before I pose sentence on that case?
I want to say, I tried my hardest. I tried my hardest to do right. I tried my hardest to stay away from women that want to see me in jail rather than see me elevate myself. So, I mean, I understand. I understand it. When I get out this situation this time, I'm gonna be by myself. I just know
You know what you ought to do, Mr. Carter, and I don't mean to interrupt you. You have the right to allocute, but I'm just going to tell you something. You ought to quit blaming them. You just need to just stop blaming them and thinking that they're the ones that stop you from going anywhere. Because, young man, that is not the case.
Yes, sir.
You are smart enough. You can do whatever you want to do. You can stay away from whoever you want to stay away from. The problem is, quite frankly, you're just being stupid. You're just playing games, and this is what happens. You end up in jail on a $100,000 cash bond, and you're about to go now.
I understand. I'll take full responsibility. I appreciate it.
Anything else you want to tell the court?
Oh, sir.
Judge, I don't know if it would have any impact on the court one way or the other, but I don't know if the court wants to wait to see the disposition of those cases, or if you're just going to follow the recommendation.
I'm not gonna wait. If there becomes a certain disposition regarding those cases, certainly I'll take that into consideration in modifying his sentence on the case, but I'm not gonna do that at this point in time. I keep giving him breaks, keep doing everything, and he keeps just coming back to this court, disappointing this court, and ending up with more charges, just time and time and time again. And so in that respect, I'm done. I'm gonna revoke the defendant's probation. He is to complete the in-jail on farm program while he's incarcerated. I'm going to waive all remaining terms except the financial obligations on this case, discharge the defendant from probation without improvement. I will sentence the defendant to 365 days in jail, credit 162 days served. Defendant is to serve the balance.
Your Honor, the court ordered the Don Farm program. Probation also requested the DV program. So if you just requested DV, the court want the defendant to perform both or just one or the other?
I should have said in-jail DV program. That's what I meant.
And that, my friends, is exactly why you don't play games with the law. Look, I get it. Everyone makes mistakes. We've all had those moments where we look back and think, wow, that was dumb. But when you get a clear warning and still do the exact same thing, that's not a mistake, that's a decision. And this guy, yeah, he made it loud and clear that he doesn't care about the rules. At this point, jail might be the only thing keeping him from walking right back into another courtroom. But let's talk about Judge Simpson for a second. This man does not tolerate nonsense, and honestly, it's refreshing. You could see the frustration on his face. He is so over repeat offenders wasting his time. And honestly,